Buckle up, because this docket is loaded with tension, defiance, and a judge who doesn't pull punches. From defendants rejecting plea deals with decades on the line, to probationers barely holding on, and even a mother fighting for her newborn while stuck in jail. This courtroom has it all. Judge Raquel West balances compassion and toughness, breaking down choices that could mean freedom, years behind bars, or second chances that might be the last. And trust me, the final bond hearing, it's explosive. Stick with me, because every case reveals just how razor-thin the line between mercy and prison really is.
Is Mr. Burbank, Mr. Smith, the sentencing on Augusta Simon? I'm sorry? Okay, we'll hold it for just... How many witnesses are you going to have?
3 or 4.
Okay. I don't know if I knew that exactly, but that's okay. We'll take care of it. Mr. Burbank.
Especially set for 11 o'clock. Was that?
Something else is at 11.
Yeah.
Yeah, something else is at 11, but that's okay. We'll make it work. Do you have other courts that you need to be in, Mr. Burbank?
I've got a passport to be in a foreign country at 10 o'clock.
Was he being serious?
No, I don't know.
Pardon County. I've got a big docket.
Oh.
I've got a big docket up there.
Okay, if you can contact and make sure whoever's coming is on their way so we can get it taken care of, since it was set at 9 and Mr. Burbank's here.
Your Honor, if I may, I think there's some emails that came over this morning in reference to my client from some family members that came in about 6 o'clock last night.
Okay, did you send those to Ms.
did.
Holmes?
We're supposed
Okay.
to forward them to the court.
Okay, I'll take a look at them in just a minute as well. See, Mr. Parker, are you ready on Devonta Anderson as the sentencing? Do you
I
need-
could talk, I want to go over this with you.
Sure, yes, sir.
He said something court on this.
What about Dedrick Davis, Mr. Parker?
I think they're fingerprinting.
Okay, I'll hold that. And Alvin Lewis?
They're, I think they're, I need to go tell them, I need to go relay a message to the prosecutor. We thought one of the cases dismissed, so.
I'll hold that. And then Almeda Miles is your last one.
It's, I've signed her up.
Okay, as soon as all those come through. And I'll go and let you talk to him about that, and I'll get you all taken care of in a minute.
Thank you.
All I have on, I guess.
All right, you can let them read that one if you want. Mr. LeBlanc, do you need a minute on Linton Arseno? Well, morning, Mr. Hoffman.
Morning.
All right, sir, you're Linton Arseno, and Mr. Arseno is charged with failure.
Here's the first bombshell. Linton Arseno, facing charges for failing to register as a sex offender, is offered 10 years. Not great, but here's the kicker. If he goes to trial and loses, he's staring at a minimum of 25 years as a habitual offender. Think about that. 10 years versus 25. Most people would grab that plea deal and not look back. But Arseno? He rejects it. Bold? Maybe. Risky? Absolutely. What would you do here? Take the 10 and guarantee release someday? Or roll the dice with 25 years on the table?
To comply with sex offender registration requirements, we've gone over before with, yeah, I think that was maybe with Mr. Lewis before you were appointed, and what the offer was and rejection, and what's the status?
The state's not gonna go any lower, Judge. That's the only offer, and it's gone today. So he can take it today, or he can go to trial.
Okay, thank you, Mr. Hoffpower. Mr. LeBlanc?
And I've conveyed that to him, we've discussed it. And my understanding is you can be more rejected or you can
You want to go to trial? Okay, so I just want to make sure, and we've gone over this before, you understand if you go to trial and you're found guilty and those prior convictions are true, that you would be considered a habitual offender. Your minimum punishment would be 25 years, you understand? And it looks like that offer that was made is for going on count one only for a 10-year term in prison. Again, you've got every right to reject that and go to trial. Just want to make sure you understand possible consequences, options, and all of that. All right, then we'll get it set for trial, and Mr. LeBlanc will begin preparation for trial. See, is Mr. Smith?
He's here, Judge, he was just, he's got witnesses outside.
Okay.
Hearings, is there something else?
I just want to get that started no later than in 5 minutes, so that Mr. Burbank, we can get him, he's got to go to another county. So if you want to let him know, I'm ready to get it, oh, there you are. Are you ready to go ahead and get started?
We've got some here, I'm just making sure that the law got here before we get started.
Okay, is she here?
I don't know, somebody will just arrive, I'm gonna walk upstairs.
Okay, I want to get started in 5 minutes, please. Charlie's. Mr. Rojas, let's see. You have Lawrence Jackson?
Yes, ma'am, we just, I don't think we can bring it.
Okay, let's see. Janesha Leonard, Mr. Coleman, and Mr. Rojas. Did you have that printed out? That's fine, I'll pull this up here. Good morning. You had that other stuff that he did printed out for me. Did you bring, did I keep it on my desk? Thanks.
Janesha Leonard.
Janesha Leonard? Okay, while they're getting her, let's, Ridley McKinley? Y'all got something you worked out, Mr. LeBlanc?
Yes, sir.
Okay, so don't get rid of that one off the docket yet. Good morning, are you Ridley McKinney?
Yes, ma'am.
Or McKinley, I'm sorry. Mr. Rojas, will your client waive the formal reading of the
He
motion?
will, Your Honor. And I think we just go on counts 2 and 3 on this.
We do, Judge. We're not gonna go forward. We're gonna, draw allegations.
Okay, state's gonna abandon one. Will he waive the formal reading of that motion?
He will,
I
Your
just
Honor.
asked you that, I'm sorry. Mr. McKinley, in cause number 19-33345, I have a motion to revoke your.
Now, McKenna's case is the definition of walking a tightrope. He's on probation for aggravated assault, already serious, and admits to being somewhere he wasn't supposed to be, plus falling behind on court fees. Normally, this is where probation gets yanked and a 5-year sentence kicks in. But instead, the state drops other allegations, and Judge West hits him with a 60-day jail sanction while keeping him on probation. Here's the dramatic twist. She flat out warns him that any slip-up, late curfew, money problems, even drama with his wife, and he's going straight to prison. That's not a warning. That's a countdown.
Community supervision shows that you were placed on probation August 1st of 2022 for the offense of aggravated assault family violence, and that was a 5-year term in prison that was probated for 8 years. Is that correct?
Yes, ma'am.
It alleges in count 2 that you were at a location other than, that you violated your probation because you were at a location other than your residence at approximately 10:24 p.m. April 9th of 2025. And is that true or not true?
It's true.
And then count 3 alleges that you are behind in your court assessed fees. Is that true or not true? And what is the status of that offense from count 1?
I believe it's been refused.
Judge, it was refused by our office.
Okay.
So, and the layman witnesses, it's the same as this one, but therefore we refused. We're not gonna go forward with the allegation.
Okay. Is there a no contact order in the probation
No,
though?
they're married.
They're married, Judge, and it's, I know the optics of it looks bad for the kind of offenses that he's on probation for.
Y'all hold it down just a little bit. Go speak.
So it looks bad for the kind of probation, case that he's on probation for, but the complaining witness has come to my office, I've spoken with her, I think
We followed up with the judge, if we had it to move forward.
Okay, I just wanted to check. All right. Did you enter your pleas of true to counts 2 and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation.
This moment is vintage Judge West, firm but brutally honest. She tells McKenna straight, volatile relationships and probation don't mix. If he can't keep his home life in check, he's looking at 5 years locked up, no excuses. Notice how she frames it as a choice. Stay in a toxic cycle or lose your freedom. That's raw accountability. But it also raises a question. Should judges be stepping into personal relationships this way? Or is that exactly what keeps probationers from failing? Drop your thoughts below, because this one's controversial.
And order 60-day jail sanction, and it looks like you've got 44 days credit. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. McKinley is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order a 60-day jail sanction as a condition for that. These allegations, you will get credit for 44 days. Here's the thing, something's going on, okay? And even at this point, if I think something's going on, the proof that is required for me to revoke your probation is not the same as it's required if we go to a jury. And if there's anything that happens again, whatever's going on between you and her, if y'all are not good together, then don't be together, because you're going to end up in prison. The offense that you're on probation for is obviously very serious. You've already agreed, when you got this probation, you already agreed to that 5-year sentence in prison. You violate your probation in any way again, you've got the 5 years. I don't care if it's having to do with her, if it's being out past curfew, if it's not showing up for appointment, this is it. So whatever's going on, y'all need to get whatever help you need. If it needs to be separated, then you need to be separated. Otherwise, you might end up in prison. So you have to figure out what's really best, to be in a volatile relationship in front of your children or to be in prison.
Yes, ma'am.
You understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. As soon as you're released from jail, first thing you do, report back to probation, get going on everything like you're supposed to. All right, good luck to you. Okay, did they get,
Jackson, but I don't think it's been printed yet.
Miss Leonard, y'all have Miss Leonard? Come on up, Miss Leonard. Janesha Leonard, 3 cases are called.
Now comes a heartbreaking turn. Janesha Leonard has been in jail for 14 weeks while her newborn, just 2 months old, struggles with a heart condition. Leonard says her baby can't latch to bottles because she was breastfed from the start. Imagine being locked up while your infant battles health issues. Every parent's nightmare. But here's where the law collides with humanity. Leonard's probation violations include a new theft charge and unpaid fees. Judge West shows compassion, setting her bond at $5,000 each on 2 cases, but makes it crystal clear. This isn't freedom, it's a chance to prove herself. Do you think the judge went too easy here? Or was this the right balance of empathy and accountability?
All right, you're Janesha Leonard. And Miss Leonard, in cause numbers 19-333-40 and 20-36095, on probation for theft of property and theft of service. And a motion to revoke has been filed in each of those cases. There's a new offense indicted 250297 with the allegation of theft of property. And so that theft new allegation is from offense date of August of 2023. And so obviously that was some time ago. There's a motion, let me get to the right paperwork. In each of these cases, obviously alleging that new offense. Mr. Rojas has filed motion in each of those motion to revoke probation cases that I set a bond, that currently they do not have a bond. Those are deferred, correct? Are they both deferred? Let me double check.
I think they're straight probations.
They're straight probations?
They are.
Okay. So Ms. Leonard isn't necessarily entitled to a bond as if it were a deferred, but we're here to talk about that. Mr. Coleman has filed a state's reply to that motion. I have read and reviewed that and obviously understand Mr. Coleman's position. Mr. Rojas, you may go forward.
Call Ms. Leonard, John.
Ms. Leonard, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay.
Okay, Ms. Leonard, how long have you been in jail now?
14 years.
And it's my understanding that you've got a newborn baby at home? How old is that child?
3 months.
All right, and there's a little, you're having, or before you come in, you were having issues with breastfeeding or with feeding child?
Yes, ma'am.
Tell the judge about how it's.
My daughter's been breastfed since she was hospitalized at 3 weeks old. She also has a heart murmur. And since I've been in here, they've had trouble with her latching on to a bottle.
So let me ask, it looks like in these motions, the primary allegation obviously is that new offense. And then there is some community service hours and then very behind in fees and fines. Other than those things, I've got probation here. And if you'll just state your name for the record, ma'am.
Linda Core.
And is there, other than those items, is there any other issues that you are having with Ms. Leonard that I need to be aware of?
No, Your Honor.
Okay. If this new allegation was more recent, I'm not sure what happened with the timeline on this, and doesn't, for this purpose, I guess, doesn't really matter. But because it's been so long, and it looks like, other than some fees and community service, everything else has been going well, I'm going to grant the motion to set bond in cause numbers 19-33340 and 20-36095. I'm going to set the bonds in each of those cases at $5,000 in each case. And obviously, if you make those bonds, the first thing you do is report to probation and do everything you're supposed to be doing while you're on probation. Yes, ma'am.
Is that included with the $10,000 bond with the new charge?
You have 3 different bonds. You've got a $10,000 and 2 $5,000s. And so you need to get busy, because while this is pending, obviously would be, I would think, in your benefit to try to get some community service hours done, to get a job, start making some payments, show me and probation and the district attorney that you're trying, because just me setting bonds doesn't mean that you're out of trouble for this. You could still go to the state jail prison. So it's very important that you do everything that you're supposed to while you're on the probation, okay?
Yes, ma'am.
All right, we'll see y'all back at an announcement. We'll worry about that later, yeah. I can't imagine that's gonna be. Oh, I'm not gonna do, okay, I don't need that. That's all right now. Got it. Hallie Rolls, Mr. Rojas. And then we'll take a break, and I'm gonna have to do a hearing with Mr. Burbank. Mr. Burbank, I'll take care of your case next. We'll get started as soon as I'm done with this. Is this for both or one?
One's a motion to revoke.
Oh, okay. This is,
Oh, did I put the wrong number on?
no, you just didn't finish. That's all right. Okay, so let me go. Are you Hallie Rawls? Will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Ms. Rawls, in cause number 25 DCCR 0623, let me pull up the wrong one. You're charged with
Holly Rolls steps up and does what most defendants eventually do. She pleads guilty. 2 cases: drug possession and probation violations for unauthorized vehicle use. Judge West is meticulous, walking her through every consequence. 2 years in prison here, 12 months in state jail there, running at the same time. Then she makes sure Rolls knows she's permanently barred from owning a firearm. Notice how smooth this exchange is compared to the others. No drama, no pushback, just a clean, efficient plea. But here's the kicker. Some might say, Rolls got off lightly with concurrent sentences. Do you agree, or should her violations have stacked up harsher?
the third-degree felony offense of possession of a controlled substance from May 30th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
In that case, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Rawls is not competent?
No, Your Honor.
All right, ma'am, in cause number 25-0623, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24-1987, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation January 27th, 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 13th, 20th, March 6th, 20th, and April 8th of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not provide verification of performing the community service as required. Is that true or not true? Count 4 alleges that you did not provide verification of completing the theft prevention class. Is that true or not true? Count 5 alleges you're behind in your court-assessed fees. Is that true or not true? And then count 6 alleges that you failed to complete a mental health evaluation. Is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have some documents in that case here on the computer that have your signature on them that the state's marked as exhibit number 1. Did you also sign and go over these with Mr. Rojas? And do you fully understand them? State tenders number 1.
No objection.
It's admitted. I'm going to find, Ms. Rawls, that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find that those counts true, again, that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These sentences will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. That's okay. I caught him. Quick reflexes. Hold on just a second. What do you need, Mr. Samuel?
Right, it's a quick hearing, just a quick motion on appointment of an expert as well as to set bond. I have a 10 o'clock dinner.
Okay, Mr. Burbank's supposed to be in.
Your Honor, I've contacted or notified the court that I'll be
Okay,
Yeah, I spoke to him,
okay.
if you don't mind. Cody Dent.
Cody Dent. And this is a bond hearing on the 2 MTRPs.
Yes, yes.
I've got 4 too, but I guess we'll just do it after Burbank's hearing, but I've got 4 that are in custody that they may want to transfer.
Everybody here's got all the
I'm
things
just
this
saying,
morning.
I can wait, because they just may want to hear.
Everybody's in jail today, so thank you. And you've got something at 11 also, so you've got a hearing at 11. So we're gonna take care of some other things since you've got that anyway. If you've got anything to sign up or work on, you can get that taken care of before. All right, are you Cody?
And now we hit the climax, Cody Dent. He's already on 2 felony probations and is accused of stealing tires from a shipping container at Discount Tire. But Dent claims he thought the tires were trash, like he was just dumpster diving. Add, in his mental health struggles, his SSI income, and living with his grandmother. This is not your typical defendant. His attorney argues he needs treatment, not more time inside. But public safety is on the line, and the state paints it as straight-up burglary. This clash sets the stage for Judge West's hardest call of the day.
Dent.
Yes, ma'am.
And Mr. Dent has 2 motion to revoke probations and cause numbers 13-17772 and 22-41052. And there's a new offense, a burglary of a building, in cause number 250807. Mr. Samuel has filed a motion asking that I set a bond in those 2 MTRP cases. Is that correct?
Yes, Your Honor.
And let me get that pulled up.
As well as the motion for access to mental health expert.
That, I probably don't even need to have a hearing. If you've filed the motion and there's,
Yes.
I'll look at it once you, if you'll just get it all filed with that attached to it, it needs to be e-filed, I'll take a look at it, it's no problem typically, as long as you have that affidavit of indigence attached.
Yes.
Okay, so. Oh, here it is. So are there no bonds set at the time?
Correct.
Okay, and are they deferred?
Yes.
They are both deferred. Mr. Smith, what is the state's position with regard to
Actually,
bonds?
I showed on F-22 4105 it's a straight probation, 2 years, suspended for a period of 5 years.
Which one?
The second one, which would make sense if he got on probation after he was already on probation. Give me just a second. I want to take a look at the PC and that new offense, and then I'll let you put on any testimony you need. All right, I'm printing something. Do you wish to call a witness, Mr. Samuel?
Yes, I call Mr. Dent.
And you need to speak up so the court clerk can hear you, please.
Mr. Dent.
Mr. Dent, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. Go ahead, Mr. Samuel.
Yes, Mr. Dent, you were placed on probation initially in 2015, is that correct?
Yes, sir.
Okay, and since that time, you had one other charge that came up, is that correct?
Yes, sir.
Okay. Right now, are you presently under the care of any doctor facility?
It's been a time.
And are you presently on medications at this time?
Yes, sir.
Okay, and what medications are you?
Ooh. Don't make me lie, I don't know them by heart.
Okay, you live with, who do you live with?
My grandmother.
And you don't have any children, is that correct?
No, sir.
And your only source of income is from SSI?
Yes, sir.
Okay, and with that, now, going to the date in which you were last arrested, that was, when it says burglary of a building, that was a container, is that correct, at a business?
Yeah, well, I thought it was a gypsy dumpster.
Okay, just answer the question that I asked you, please. Okay, it appeared to be a dumpster, is that correct?
Yes, sir.
You didn't think that was anything wrong with getting something, you thought it was trash, is that correct?
Yes, sir.
Okay. At that time, had you had your medications?
No, I didn't take it immediately.
Okay. Your Honor, we believe that, I passed the witness, Your Honor.
Any questions with regard to this hearing?
No questions regarding this or that.
All right, give me a second. I'm reading the pre-sentence report, the PC.
Yes,
So
ma'am.
it shows that this was, the allegation is from theft at Discount Tire.
Right,
And there was a shipping container,
right,
and he was allegedly removing tires and placing them in his vehicle.
right.
And this, the business apparently was closed, signs on the container.
And we will show the container, the signs, they somewhat obscure, but they were
Well,
there.
but they're on the business
Right.
property with tires that belong to Discount Tire business.
Used, and the value of the tires were
Doesn't matter.
$50 a piece. I
Okay,
understand.
I guess I just want to make sure the problem is if we're having, okay. So the first probation was for obstruction or retaliation placed on that probation 2015
Correct.
for 5 years. I'm assuming that has been extended. And then while on that probation, there was a theft of property, was continued on the first probation, placed on probation in February of 2023 for a 5-year straight probation. And now we've got a this.
Correct.
Okay, I think at this time, based on the nature of the underlying offenses and based on the allegation in the new offense, based on the fact that there are some obvious mental issues, I don't know that it's in the best interest of anyone for me to let Ms.
Here it is, the gavel drop moment. Judge West denies Dent's bond. Her reasoning? He's on 2 active felony probations, accused of a new felony, and admits he didn't even think stealing tires was a crime. She bluntly says letting him out would be a danger to the community, and maybe even to himself. Instead, she orders a mental health evaluation, keeping him locked up. It's a tough call, but one that shows her priority. Public safety first. And that wraps up this wild docket. Plea rejections, probation chances, parental struggles, and a final bond denial that left everyone stunned. If you found this breakdown as jaw-dropping as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom drama dissected like never before.
Mr. Dent back out to be doing the same thing. It sounds like he's stabilized. I want to make sure he is. We can get an evaluation done. We'll get you an expert, and then we'll set it for a hearing. But I'm not going to grant the motion setting a bond. I don't think that is in the best interest of our community or Mr. Dent for that matter.
Why can if you excuse me, can I ask you something, Ms. West? Why can I not get a bond?
Because you're on 2 felony probations, and the allegation is that you committed another felony offense.
I don't think there was a